Sarah spent 3 years writing the book. She had the research notes, the interview recordings, the chapter drafts, the revision history in Google Docs, every time-stamped version of every page from the first paragraph to the final proof. When the publisher sent the advance copies in January, the author credit read, James Holloway, with contributions by Sarah Chen. James Holloway had written a 4-page introduction. Sarah had written 287 pages. What happened next took 6 months and cost James everything he thought he had taken.
The arrangement had started legitimately. James was a well-known name in their industry, which gave the book's proposal credibility with publishers. The agreement, verbal, then confirmed in a 3-sentence email, was clear. James would provide his name and a foreword. Sarah would write the manuscript. They would split royalties 60-40 in James's favor in exchange for the platform access his name provided. What James did in the month before publication, going to the publisher directly and representing himself as the primary author, was not in any version of that agreement.
Sarah's attorney filed a copyright claim within 2 weeks of receiving the advance copy. The legal basis was straightforward. Copyright in a written work belongs to the person who wrote it, and Sarah had 3 years of time-stamped drafts, revision histories, and communication records that demonstrated authorship beyond any reasonable dispute. The publisher, facing a claim from the actual author of a book they had printed under a different person's name, moved quickly. They did not want to be in the middle of this.
James's attorneys spent 2 weeks arguing that his editorial contributions and industry network justified the primary authorship credit. Sarah's attorneys submitted the Google Doc revision history, 847 saved versions spanning 36 months. Alongside the original 3-sentence email agreement, the publisher pulled the print run. 3,200 copies were recalled from retailers. The book was reprinted with a corrected author credit and a revised royalty structure. James received credit for the introduction he had written. He received royalties on that basis only.
The financial outcome: James returned the full advance he had received under the false authorship claim, approximately $47,000. Sarah received the full advance due to the primary author, the corrected royalty stream, and a separate damages award for the delay to publication caused by the recall. The book, once properly published, performed well. The industry, which is small, found out what happened. James has not published since.
The lesson here is about documentation not as defense but as foundation. Sarah had those time-stamped drafts not because she anticipated being defrauded. She had them because she had been working on the book seriously for 3 years, and working writers generate revision histories. The document trail she needed already existed because she had done the work. The fraud undid itself against the simple weight of what was already there.
The 3-sentence email agreement that confirmed the original deal was the pivot point of the entire case. James's attorneys tried to argue it was informal and didn't constitute a binding contract. The judge found it clearly established the terms and that James had materially violated them. 3 sentences, 3 years of drafts, 6 months of legal proceedings. The book is on shelves under Sarah's name. Subscribe.